When you're facing a felony in California, before you can go to a jury trial, the prosecutor must prove the case in front of a judge or a grand jury. The process of proving the case before trial in front of a judge is called a preliminary hearing. In short, a preliminary hearing is a pre-trial hearing where a judge determines if there is enough evidence to hold the defendant for trial. It is basically a mini trial. The preliminary hearing burden of proof is probable cause, and that's a lot lower than reasonable doubt. The purpose of the preliminary hearing is to ensure the prosecution has a valid case and there's sufficient evidence to proceed to trial. The timing of the preliminary hearing is it must be held within 10 court days of the initial arraignment, but no later than 60 calendar days of the arraignment. But this time can be waived by the defendant. The procedure for a preliminary hearing is that the prosecutor will present evidence that is done in the form of exhibits or testimony by officers or witnesses or even experts. Defense will have an opportunity to cross-examine these witnesses, but it's really limited. Sometimes a judge doesn't allow a lot of cross-examination. Unlike a jury trial, though, in some circumstances, hearsay evidence is allowed in preliminary hearing, where in jury trials, it's not allowed. And the preliminary hearing is presided by the judge, where the judge will determine what evidence is admissible, and the judge determines whether or not that evidence meets that threshold so the case can go to trial. While at a jury trial, the jury determines what charges are true or beyond a reasonable doubt, while the judge in a jury trial just determines the law. And at the end of a preliminary hearing, the judge determines if there's enough evidence to hold the case for trial. And the judge at the time can make a determination, well, maybe this should be a misdemeanor, not a felony. Or he could say, hey, there's not enough evidence, so therefore, I'm not going to make a holding order. If the judge finds there's enough evidence to hold it for trial, the defendant will get another arraignment and pick a date for the jury trial in the future. And the danger with a preliminary hearing, though, of course, is the judge can also determine at the end of the preliminary hearing if the bail is sufficient, and the judge can increase bail or lower bail after a preliminary hearing. As you can see, a preliminary hearing is a very important hearing on the road to a jury trial in your case, and this applies in California. Thank you. Have a good day.